things to finish off from last class when we were talking about actually applying for a refugee claim, actually making a refugee claim in Canada, filling out the forms, doing the basis of claim or the Bach form and the narrative, and just the general process that goes along with that. So we don't have too much more to finish off from that, and then we're going to get into our topic for today. So we left off really at the end here, after talking about preparing the Bach and the kinds of things that you need to think about with that. The last thing I want to cover are amendments. So what do you do when you've filed the Bach form and the narrative, and then you need to make some kind of change to it, either delete something, add something, or change something in some way? So this is possible, okay? So amendments to the Bach form and the narrative are possible. There are rules relating to it that I want to go through. It's really important to keep in mind. So first of all, in terms of when an amendment is needed, there's a lot of different situations where you might need an amendment. Sometimes there's new important information that has come up in the claimant's case after they filed the Bach. For example, let's say they came to Canada, they made their refugee claim, they filed the Bach form and the narrative, and then sometime between filing the Bach and the hearing, they heard from their family in their home country that the agents of persecution have been looking for them. So that is an important new piece of information. And in that case, I would amend the Bach to include that information. So that's an example of new, important, and relevant information that you would want to put in the Bach. Sometimes you discover that there are errors, inconsistencies, or some kind of omission in the Bach, or the claimant remembers something. This often happens while you're doing hearing preparation. So one practice that I have started is making sure that I do at least one hearing preparation session with my clients before the filing deadline for disclosure and other information before the hearing. So as you'll see in the rules for the RPD, there's a 10-day filing deadline for Bach amendments. So you've got a hearing date of August the 20th. That means that any amendments to the Bach have to be filed 10 days before that, so by August the 10th, as well as disclosure. That's also due 10 days before the hearing. So while I try to do a lot of hearing preparation close to the hearing so that it's fresh in the client's mind, because of this 10-day filing deadline and the fact that often when you start questioning clients and preparing them for the hearing, things come up and you realize that you either need to change the Bach or amend it or something like that, I do try to do one hearing preparation session with clients before that hearing, before the filing deadline. So that means that, let's say you're doing your first hearing preparation session with a client, you're questioning them and practicing with them and going through, you know, what's going to happen at the hearing and asking them questions about their story and about the Bach and the narrative. And they disclose to you that there was an arrest in their home country that they didn't put in the Bach narrative for some reason. So if something like that happens, you have to, you know, get the client to explain it and then, you know, advise them on whether, you know, they should amend the Bach or not. And if it's something important, either something that was not included in the Bach or that was included but that was a mistake or contains wrong information, it can be really important to amend the Bach because as you will see in hearings, if the claimant mentions something important, relevant to their claim that was not included in the Bach, the member is going to question them about that omission, and it could have a negative effect on their credibility. The same goes with information in the Bach that's incorrect. So, you know, anytime information comes to your attention that makes you think, oh, we might need to amend the Bach, you know, you need to discuss that with the client and get their instructions and then proceed on that basis. So if you look at Rule 9 of the RPD rules, that contains the information that you need to understand the rules for making Bach amendments. So, you know, the first rule, you know now, Bach amendments have to be filed at least 10 days before the hearing date. Rule 9 also tells us that you have to provide an original and a copy of the amendment. So if you think back to last class, we learned that when you submit the Bach form and narrative, you have to submit the original and a copy. It's the same with amendments, original and a copy. The claimant has to sign and date each page that is amended or has changes. You have to underline any changes, and then the claimant has to also provide a new declaration. So on the screen here, you can see the format of amendments. I've got underlined, so you can see what I mean by that. So that means that anything new that you're adding to the Bach narrative should be underlined so that the member at the RPD, when they're reviewing the amended Bach, they know that anything that is underlined is new, that has just been added. Now, if you are deleting things, they should be, you can't just delete them and then they disappear. You have to do like a strike through or cross it out so that, again, when the member is reviewing the narrative, they can see what has been deleted. Because again, you can't just delete things completely and have them disappear. You have to show what's being deleted and leave it there, but have a strike through or a cross through it so that it's clear that it's being deleted. Now, with regard to the declaration, some people will, you know, prepare their own declaration for the client to sign. My own practice and the practice of a lot of other practitioners that I know is to actually just print a new page 10 of the Bach form. So that's the page with the declaration from the claimant and from the interpreter if they're using one, and to just have the claimant and, if appropriate, the interpreter sign that new page 10 declaration page and then attach that to the amended narrative, and then you submit that to the board. And that is in keeping with the rules. Now, I mean, again, people have different practices on how they actually amend the form and the narrative, but if you're ever going to be doing amendments, make sure that you read the rules to ensure that you're doing it correctly. Now, in terms of how to deal with amendments, like whether to give an explanation for them or to just make the amendments and then send them in, that's going to be something that you are going to have to determine through experience and with your client as well. So, for example, when you're making additions, so when you're adding information to the narrative, I would ask, well, is this an old event or is this a new event? So if it's a new event, if it's something that has happened after the Bach narrative was first filed, then I don't think you really need, I mean, you don't need to explain why why that information wasn't provided earlier, because obviously it could not have been provided earlier because it didn't happen at that point. If you are adding information about an event or something that happened before the first Bach narrative was filed, then it's a very good idea to think about providing an explanation for why it's being added now. So, you know, sometimes claimants forget things, or sometimes there's miscommunication. Sometimes claimants are not comfortable talking about some things that have happened to them, and then eventually they do tell you. So again, if you're adding information on things that have happened before the first Bach narrative was filed, I think it's a good idea to canvass with the client why that information is being provided now, why it wasn't being provided before, and then think about, you know, putting in an explanation in the narrative to explain why that information is now being provided. For corrections, the same thing. It's going to be a case-by-case basis. You know, sometimes you go through a narrative with a client and you realize that you put the wrong year, or you flipped the numbers around, or sometimes it's a bigger correction. So again, you're going to have to decide on a case-by-case basis. If it's a fairly minor correction, you might not have to provide an explanation for it, but if it's really significant, and you think that it could lead to some kind of negative credibility assessment, then again, canvass with your client what the explanation is for the correction and think about putting it in the narrative. It's certainly true that, you know, at the hearing, if the member has questions about changes that have been made to the Bach, omissions, anything like that, they will put it to the claimant, they will ask them. And so, you know, when you're doing hearing preparation with clients, you're going to want to make sure that if there are significant amendments to their Bach narrative, that, you know, they've had some practice like explaining it, and that they understand that they might be asked about it at the hearing. So, you know, if you don't put an explanation about it in the narrative, they might be asked. Even if you do put an explanation, they might be asked. So again, case-by-case basis, this is something that you learn with more experience, but yeah, anytime you're making a significant amendment, I would think about and discuss with the client whether an explanation for that amendment should be put into the narrative itself. Same with omissions, right? So as I just said before, like let's say you're doing hearing preparation with the client and they tell you something that seems important to their claim, but that was not included in the previous narrative that was submitted to the RPD. You will have to consider whether, if you're adding that information now, whether to explain why it was previously omitted. And again, you know, sometimes you are in situations where it's not, you know, really clear what you should include in an amendment and when you should amend it and whether you should amend it. And if, you know, if you're in a situation like that, again, you've got to remember ultimately the claimant is your client and the decision is theirs. So you have to advise them on the possible outcomes of amending the Bach narrative or not amending it. And then the decision lies with them, and they're fully informed when they make that decision. So a couple of, you know, best practices I just want to point out here. Again, I would, you know, make sure your clients are aware of the ability to amend the Bach. You know, I would say you probably want to do that when you're actually preparing the Bach at the beginning with them. And then also, again, when you are starting to prepare for the hearing, once the hearing date has been set, I always tell my clients before that disclosure deadline, I say, please review your Bach form and narrative carefully and let me know if you find anything that you think needs to be amended. And then, like I said, another best practice is to schedule a hearing preparation meeting with your client before that 10-day deadline before the hearing, so that you can start to prepare them for the hearing. And that way, if something comes up and you discover the Bach needs to be amended, you can do it before the deadline. Because ultimately, if you make a Bach amendment in that 10-day period before the hearing, you can still try to file it. And you can ask the RPD to accept it late. And oftentimes they do. But there's always a risk that they won't. So, you know, as much as possible, you've got to respect the deadlines, because if you don't respect them, then again, there's always a possibility that whatever you're filing late will not be accepted. So a little bit more about hearing preparation and how to use the Bach form and narrative for that. You know, we put a lot of work and time into preparing the Bach form and the narrative, and it's not, you know, that's not the end of it. So hearing preparation also involves quite a bit of work with the client. And I always like to go over how you can use the Bach when you're preparing for the hearing. So you can use it in a number of different ways. So first of all, after, let's say you're dealing with an inland refugee claim. So after you filed the application package with the inland office, including the Bach, the client has their eligibility interview, they're found eligible, and their claim is referred to the RPD. So after that point, there's really nothing further to do but just to wait for the hearing date to be set and to, prepare the evidence and the disclosure for the claim. So what I like to do is to prepare a memo or a letter that I give to the clients that basically sets out or lists the kind of evidence I think they should gather. And I use their Bach to help me prepare that list. So, I've got like a template that I use, and then I will go through their Bach narrative line by line. And I will use that to come up with ideas and the list of evidence that I think they should gather. So that's the first thing. The second thing is it's always a good idea to review the Bach before you're doing country research. So, in refugee claims, when you're preparing the documentary evidence that you're going to submit to support your client's claim, as you know, there are two types. There's personal evidence, which is specific to the client, and then there's also country condition evidence, which is evidence that speaks more generally to the country and the conditions there, and how those conditions might, relate to your client's claim. So, and those are documents, again, that are in addition to the country condition documents in the National Documentation Package, or the NDP, which is on the IRB website. So again, before you start doing country research and looking for like articles and reports that are going to be helpful to your client, it's a good idea to read the Bach narrative, just again, to refresh your memory about the basis for the claim and the details of your client's case, because that might also sort of jog your memory and give you ideas of what you actually need to research to support the claim. Again, back to this other point that I made, next, once the hearing date has been set, make sure that the client reviews the Bach and narrative before you start preparing them for the hearing. So, a few years ago, hearings used to be set within a couple of months of making a refugee claim. So the timeline was really short. People would make a refugee claim, and then their hearing date would generally be set within a couple of months, and then it would be done. These days, as you know, people are waiting a lot longer for their claims and for their hearing date to be set. So sometimes people are waiting like a year or two before they get a hearing. So in those cases, often they haven't looked at their narrative in a very long time. So before you sit down to start preparing them for the hearing, tell them to review their Bach and narrative before you do that. As well, you're going to want to familiarize yourself with the narrative before you start preparing the client, because again, when you're preparing them for the hearing, you're going to want to be, asking them questions to get them sort of used to answering questions in a hearing setting and comfortable with talking about their case. And in order to do that and to give them, specific, direct, relevant questions, you need to be really familiar with their narrative as well. And, again, when you're preparing your client for the hearing, as you ask them questions, it's helpful to point out or identify inconsistencies in their answers, things that they say that are not consistent with the narrative. Like you can ask them a question, they give you an answer, and you say, oh, I just want to point you to like line 80 in your narrative. It says that this actually happened in 1997. You just told me it happened in 1995. Why is there a difference? So those kinds of things, that's one way that you can use the Bach to help prepare your client for the hearing. Finally, you'll want to use the Bach narrative, again, to help you identify possible legal issues to address in your legal submissions. And we're going to get into that a little bit later today. But basically, when you're first helping your client prepare a Bach narrative, it's important that you actually identify the legal issues in their case at that point as much as possible, so that you can help to include information that will address them in the Bach. But when it comes time to actually prepare for the hearing, prepare your legal submissions where you're arguing how your client meets the definition under Section 96 or Section 97, using their Bach is also going to sort of help you identify the possible legal issues that you'll need to address in the hearing or after the hearing if you're doing written submissions. So I hope that illustrates for you just how important the Bach is and how you can continue to use it to prepare yourself and your client for their hearing after it's been filed. The final thing that I want to mention briefly are just some of the changes in making refugee claims that are in place due to COVID right now. So, I would encourage you at first to just look at the IRCC website. I've got the link here. You can just Google it. But I would look at the changes and keep updated on those if you are doing work in this area. So right now, you can still make an inland refugee claim. However, we're not making them in person right now. So as I explained to you last class, when you make an inland claim normally, you take your application package and you just show up at an inland office that does that kind of intake in Canada. Right now, those offices are not open to people, so you actually make the claim online. So if you go to that link, you will see there's an email address specifically for inland refugee claims. And what you do is you send an email to that email address with your client's name and some other information, and that will initiate the claim. So that's basically you're notifying IRCC that this person wants to make an inland refugee claim. Then what happens is IRCC will set up a message exchange on ePost Connect, which is that online platform that's run by Canada Post, and it's used for communicating with the RPD and IRCC right now. They will set up a conversation message exchange for that particular client, and they will send you a letter that basically lists the forms that you need to provide, and they give you 30 days to do that. So once you get that, everything gets prepared, and then you actually file all the forms along with the Bach form and narrative online through ePost Connect to IRCC. IRCC gets that, they review it, they might come back to you and ask you to make changes to the forms, they might ask for more information. Right now, obviously, because this is being done online, IRCC needs proof that the person is actually in Canada, whereas before with inland claims, obviously the person shows up at the IRCC office, it's clear that they are physically in Canada. But right now, because inland claims are being made online, you actually have to submit proof that your client is in Canada. So that can be, like a copy of their passport with a visa and entry stamp. If you don't have that, you could use like a flight itinerary, boarding pass. You can also show like a lease agreement if they're renting somewhere, or if they're, for example, if they were staying in a shelter, get proof of that, or utility bills. Again, there's a lot of different things you can show to prove that your client is in Canada, but that's like an additional sort of piece of the documentation that you have to submit now that you did not have to submit before. So after IRCC checks everything, confirms that it's, complete, they will send an acknowledgement of claim letter to you, again, through ePost Connect. And that letter will basically say, we acknowledge that we've received your claim. You are now eligible for interim federal health protection or coverage. And then they just basically say you have to wait for your eligibility interview. Now, the challenge right now that a lot of people are facing with these new changes are that eligibility interviews are proceeding very slowly. So there are still a lot of people who made claims, inland claims in like March, April, May last year, who have not had an eligibility interview yet. Because again, these are usually done in person. And so these IRCC inland offices are not doing them right now, or they're doing them very slowly. In the last couple of weeks, we've started to see some movement. They do seem to be scheduling some of the eligibility interviews, but unfortunately, the wait time right now is months. If you'll remember from one of our previous classes, refugee claimants cannot file for a work permit or a study permit until they've been found eligible and their claim has been referred to the RPD. So right now, with this new online way of making inland claims, refugee claimants, luckily, they do get access to the IFHP health coverage. They can also apply for social assistance, but they can't get work permits and study permits while they're waiting, which is really a huge issue for a lot of people because, you know, a lot of refugee claimants, they don't want to go on social assistance, they want to work, but they have to wait for authorization for that. So that's, you know, one sort of big issue that we're seeing with inland claims right now. And we're waiting to see how that changes and hopefully how it improves. So that's the sort of big change to the inland claim process, which is currently in place because of COVID. In terms of port of entry claims, you know, at the land border, so they can still be made. Of course, the Safe Third Country Agreement still applies. So, you know, the person coming through a land border, port of entry to make a claim, they have to fall within an exception to the Safe Third Country Agreement to be eligible to make a refugee claim. I mean, I believe that officially irregular entry from the United States right now, so remember, irregular entry refers to people coming over the land border between official port of entry points or making claims at an airport when they've come from the US are supposed to actually be directed back to the United States. However, it does seem that if people enter Canada irregularly right now across the land border and they're able to get into Canada, they still are able to make a refugee claim as before. Again, you know, with COVID and the changes that are happening, I would encourage you, if you're dealing with any of these issues, to look on the IRCC, look on the CBSA website, and make sure that you've got the most up-to-date information. I mean, if you look at the statistics from last year, it's very interesting to see how the numbers have changed. They've really gone way down in terms of the number of people who are claiming protection. And a lot of that, again, is because of the COVID travel restrictions. People are not able to actually physically get to Canada to make a claim. One more thing, I guess, to point out about port of entry claims in the time of COVID is that there, you know, if someone's thinking of making a port of entry claim, they might want to contact the port of entry in advance or use one of those like social community service organizations in the States that help people make claims at the US-Canada border. Because I know that, again, with COVID and some of the new things that are in place at port of entries, sometimes CBSA is requiring people to actually make appointments to come and make a port of entry claim. So for example, I talked to someone a week or two ago and they were in the States. They fell under an exception to the Safe Third Country Agreement. And they wanted to come to Canada to make a claim at the port of entry. They ended up contacting the port of entry, CBSA at the port of entry, notifying them that they wanted to make a claim, and they were given an appointment, I think 2 or 3 weeks in the future to come to the port of entry with the forms all filled out and ready and to make their claims. So again, claims can be made, but with COVID and everything that's going on, there are certainly some changes.
Sorry, and I have a question.
Yeah, of course.
How does this apply to irregular border crossers? Do they still get the eligibility at the border crossing there?
So, I mean, it really, it kind of depends. I mean, there's different, I guess there's sort of different types of irregular border crossers. Like, you know, when people are crossing at like Roxham Road out in Quebec, I mean, that is a main border crossing. I believe that there's usually like RCMP or CBSA around that area to assist people when they're, crossing.
Okay.
Again, with COVID, I'm not sure what the exact situation on the ground is right now, but in situations like that, generally, regular border crossers are usually like apprehended by the authorities and then taken to, they're often taken to an official port of entry to do the claim and do the eligibility interview there. But other times, some people cross the border irregularly and then they actually make their way to like a city like Montreal or Toronto. And then when they get there, then they actually make an inland claim. So basically they cross irregularly and they're not discovered or detected by the authorities. And then they just come into Canada and make a claim on their own time. So I think it kind of depends, whether they are stopped by the authorities or whether they call the authorities and say, hey, we've just crossed over, please come get us, or they make their way to like a city and make an inland claim that way. I mean, if you look at, I haven't looked at it in a week or two, but I believe if you look at the IRCC website, let me just see. I'll pull it up later and I can circle back to this.
Okay.
But, they were saying that, people coming into Canada from the US would be turned back if they made a claim. And that was the official line. However, like I said, I have talked to people and heard from other practitioners that people are they are coming across irregularly still and making claims, and they're not turned back. So I think it's, still, people are still making claims in the same way that they were before, but it's just the numbers are a lot lower. And then of course there's the issue of quarantining as well. So I think that right now, if you either do a port of entry claim or cross irregularly, you obviously they're going to ask you to quarantine for 14 days as well, and that's one of the reasons that they've put that 45-day extension on submitting the basis of claim form, to make sure that people can quarantine first and then go get legal counsel and start preparing the Bach form and the narrative.
Okay, thank you.
You're welcome. Okay, so that is really it for this topic. If anyone else has any questions, please tell me now or tell me later. But if no one has other questions on this topic, we're going to get into to today's topic. Okay, so all right, so for the next little bit, we're going to be talking about legal research. And I'm hoping we can go through some of the resources that you can use to do legal research if you're working on a refugee claim, in order to help your client and just become a little bit more aware about the types of resources that are out there for you to use to help your own practice and to help your clients. So I'm going to talk a little bit about the Canadian court and tribunal framework. We're going to go through some of the basics on case law or jurisprudence, online resources for legal research. I think that's generally what most people are using these days. We'll go through some specific resources that are online from the IRB, UNHCR, and then I'm going to spend some time with you going through Canley. So I imagine that most of you have some familiarity with Canley, although I'm not sure how much you might have used it in the past. So I will go through some of the sort of basics of doing legal research using Canley, some kind of tips for finding information on there. I'm hoping we can kind of talk through a research case example in terms of doing like issue spotting, and then talk a little bit more just about how we use legal research in refugee claims to help our clients. So, when do we do legal research? And we really do legal research at any time in the refugee claim process. There are, a lot of different points in the refugee claim process that you might need to do legal research. So sometimes you might need to do research when you're helping a client prepare a Bach narrative. For example, they might have traveled through several countries before coming to Canada without making a refugee claim. And that could raise the issue of a failure to claim and questions about whether that claimant actually has subjective fear or not. And if you're not familiar with the sort of general principles and the case law, like the court decisions that deal with failure to claim, you would need to look into it so that you can advise the client on specific issues and to help them explain the failure to claim in their narrative. So that's like one early stage where you might need to do some research when you're helping a client. But I would say one of the most sort of common reasons or points that you'd be doing legal research in a refugee claim is when you're preparing for the hearing or when you're preparing your legal submissions. So if you look at the Rpd rules, there are rules about legal submissions. So Rule 10.7 basically says that representations, or in other words, submissions, legal submissions, have to be made orally at the end of a hearing unless the division says otherwise. So this means that at the end of a hearing, you may be required to make legal submissions about why your client should be accepted under Section 96 as a convention refugee or under Section 97 as a person in need of protection. Now, this is not always the case. Sometimes you'll get to the end of a hearing and the member will not need to hear from you because they are satisfied that your client meets one of those definitions, which is great. Or you get to the end of the hearing and there's not enough time for you to make legal submissions, in which case the member might ask you to make written legal submissions and then you submit those a couple weeks later. But, because of this Rule 10.7, you always have to be prepared to make legal submissions at the end of a hearing. So that means that when you're preparing for a hearing, you're going to be preparing your client for their testimony, and you're also going to be preparing your own legal submissions about why your client meets the definition under Section 96 or 97. And so that's really the time when you're most likely to be doing some legal research to help support your case and your arguments. So, I'd say in order to best prepare for a hearing, you want to make sure that you've researched all the obvious issues that you think could come up in your client's case. Those should generally be quite clear to you after, having spent all this time with your client helping them prepare, and also by looking through the basis of claim form and narrative. You should be able to pick out the issues that you think could come up in their claim and then preparing to make submissions on those issues. Now, if after questioning at the hearing, so after the members questioned the client, after you've questioned the client, if you're asked to make oral submissions, then you will need to address specific issues that have come up in the claim, and again, explain why your client meets the definition under 96 or 97. So you really need to be prepared so that you can do that, with minimal fuss. So that's kind of the starting point for our discussion, our class today. In general, I think when you're doing legal research, you have to first, identify what's the purpose of your research. What are you looking for? Why are you looking for it? You want to identify the issue that you're researching as well. That's going to help you research it efficiently and hopefully find, the most relevant results as quickly as possible, and to really narrow down the issue to the most relevant part. one thing to consider is, are you looking at case law or are you looking at statutory law or both? So case law, as you probably know, and as we're going to talk a little bit about today, refers to, court decisions that have been made in the past. Statutory law refers to like legislation like IRPA or IRPR or, the Criminal Code of Canada. And then, one other consideration when you're doing legal research is, of course, what resources do you have access to? So one of the reasons that I'm going to be spending time on Canley today is because Canley is a free resource that is online and that has become a really great resource for people, for practitioners in this area, again, because it is an online resource that is really excellent for getting information without having to pay money for it. And of course, there are certainly paid services that you can use to research legal issues in the refugee and immigration law area. But again, that can be quite costly, and often people are, looking to see what are the best free or low-cost resources out there. So that's another thing to consider. What do you have access to, and is it enough? And so we'll go through Canley today so that you can get a better sense of exactly what you can do on that website. So before we get into all of that, I just want to do a little refresher on the Canadian court and administrative tribunal system in Canada. So we're not going to look at this entire diagram. I just want you to look at the right side of it. So, you can see at the top, we've got the Supreme Court of Canada, and then below that to the right, we've got the Federal Court of Appeal, underneath that, the Federal Court, and then underneath that, we've got the Federal Administrative Tribunal. So that's the branch, the only branch that we're looking at, and that is really the most relevant to us as practitioners in the immigration and refugee law area. The Federal Court and the Federal Court of Appeal deal with legal issues that are referred to or that come out of the legislation that created them. So for example, as you probably know, the Federal Court hears immigration and refugee law cases, which are governed by the federal legislation of IRPA. Now, the Federal Court of Appeal, like you can see the order that they're in here, right? So the Federal Court of Appeal will hear appeals from decisions of the federal court. And then the Supreme Court of Canada at the very top is going to hear appeals from the Federal Court of Appeal. And, the Supreme Court is the final court of appeal for all Canadian courts and administrative tribunals. It's at the very top and has jurisdiction over all of them. Now, at the very bottom of the screen here, you can see that under the jurisdiction of the federal courts, we have federal administrative tribunals like the IRB, the Immigration Refugee Board of Canada. You can appeal IRB decisions like Rpd decisions, Rad decisions to the federal court. So, obviously Federal Court of Appeal, Supreme Court of Canada decisions are all binding on the IRB. Now, in terms of appeal rights and things like that, we will cover that in a later class. But I did just want to, give you a little refresher on the structure of the court system here, because I think that will kind of give you a better context as we start to talk about case law and legal research in this area and how it all fits together. So in Canada, we are a common law system. Now, Quebec is a bit different. I'm not going to be talking about Quebec, but for the rest of Canada, we are a common law system, and that means that our law develops through case law using what we call a precedent system. Precedent, basically, it means a system where a court has to decide cases, new cases, in line with the previous cases that deal with the same legal issue that have been decided by courts of the same level or higher. So that basically means that for, federal court, for example, when a judge of the federal court is making a decision within this precedent system, the decision that they make when they're making new decisions on new cases, they generally have to make their decisions in line with previous cases from either the Federal Court of Appeal, or the Supreme Court of Canada that have dealt with the same issue. Of course, depending on where the court or tribunal falls within the system, that's going to dictate which decisions of which courts like above them are going to be binding on them. So as you can see on the slide here, for Canadian refugee law, generally we're looking at Supreme Court of Canada at the top, Federal Court of Appeal, then the federal court below that, and then finally our level at the IRB, which we have the Refugee Protection Division and the Refugee Appeal Division. Now, one thing that you'll probably hear a lot if you're looking at case law and precedents are the words binding, persuasive, and distinguished. So that just really refers to the use of precedent of previous case law, case decisions in new decisions, and how they affect the decisions of courts and tribunals on new cases. So if we're talking about a binding precedent, that means a precedent that has to be followed. So the Supreme Court of Canada is the highest court of appeal in Canada. Cases that come out of the Supreme Court, their decisions are binding precedent on the courts below them, which means the courts below them have to follow them. Persuasive precedents or decisions are cases that do not necessarily have to be followed, but they can be persuasive. So for example, like let's say the Refugee Appeal Division. Let's say you're doing an appeal at the RAD, and you have found a few previous RAD decisions, so at the same level, previous RAD decisions that might be relevant and helpful in your client's case. Because the decisions are also from the RAD, so they're the same level of decision maker, you wouldn't say that those decisions are binding. So those decisions are not going to be binding on new decisions of the RAD, but they might be persuasive, which means that you could submit copies of those previous RAD decisions with your client's RAD appeal, and you could argue that those decisions are persuasive and that they should be followed in your client's case. Distinguish refers to when you are distinguishing or setting apart a case from another. So, a lot of the times at federal court, for example, when we are making arguments for our clients, the lawyers for the other side, for the government, will say, well, here's this federal court case that says that your client's refugee claim was right to be refused. And what you can do is you can try to distinguish that case, which means you can try to argue that that case is distinguishable, like on the facts, for example, and that it's not applicable in that particular case. So, I realize this is, a lot to take in, and this is something that will probably require sort of more practice and reading in this area, but I just wanted to make you aware of, the terms precedent, binding, persuasive, and distinguished, so that as you are doing case law in this area, researching case law in this area, you have kind of a starting idea of what these terms mean and how we use them in the refugee law framework. So in terms of online resources for legal research in this particular area, I've got a list here on the slide, and we're going to go through some of them today. So we've got the UNHCR Handbook, IRBA, obviously, IRBR, the Refugee Protection Division rules, the Refugee Appeal Division rules. We've got the IRB legal resources, which I'm going to go into in some detail. the IRB's Chairperson Guidelines, and then of course we've got Canley. So, you know, if you're not familiar with some of these resources, I would encourage you in the coming weeks to go to these links and read through them and see what kind of information is there, so you are, you know, a little bit more aware of the resources that are available to you online for no cost. Now, a quick note, as we're going to see, you know, Canley is a legal research database, and there are, of course, other legal research databases. I'm not saying that Canley is the only one or the only one you should use. There are other well-known ones like Quick Law, LexisNexis, Westlaw. Now those are a paid service and they require a subscription. So if you don't have one of those subscriptions or you don't want to pay for a subscription, then I do think that Canley is really an excellent free resource. Now, I would also be remiss if I didn't point out that there are also lots of non-online resources. And, you know, up until X number of years ago, you know, non-online resources were the main source of legal research. So there are plenty of textbooks and print materials that can help you in your research. But, you know, our focus today will mostly be on online research, just because I think it's extremely prevalent right now, and that's how most people are doing their research. That said, though, I do think that the principles and sort of techniques and tips for doing research online will still apply to print resources as well. Okay, so this is what I want to go through in a little bit more detail. So on the IRB website, they have a section called Legal Resources, and they have these 4 documents that are accessible to the public. So let's take a quick look at them. So the first one is the interpretation of the Convention Refugee definition in the case law. And this is really an excellent resource. I'm assuming you can see this on screen share. If for some reason you can't, please let me know, but I think I've set it up so you can see it. But this is really an excellent resource and a great starting point for doing research in the refugee law area. So the IRB has provided this document, which basically goes through the definition of a convention refugee under Section 96. And it explains the interpretation of it, and it really breaks it down into great detail, and has, you know, case law and other, you know, comments on how it's been interpreted in the past, and it's really an excellent resource. So I would encourage you to look into it. And as I'm scrolling down here, you can just kind of see the titles and the headings, which give you an idea of what is included in it. I mean, to give you like an example, like let's look at well-founded fear, Chapter 5. So if you click into that, you'll see how well-founded fear is broken down. And like you'll see here, for example, 5.4.2, failure to seek protection in other countries. And if you go to that, it really talks a lot about failure to claim in other countries and how that can affect a claim, how that's been interpreted and dealt with in the case law. So really, I encourage you to look at and use that resource. Now, the second legal resource on the IRB website is this document called Assessment of Credibility in Claims for Refugee Protection. Now, this is an older document. The one that I just showed you was updated in 2019, so it's quite recent. This is a bit older, but again, it's really a great starting point when you are learning more about how credibility is assessed in refugee claims. And next class, next week, we're actually going to be doing a whole class about credibility, and I'm hoping that it will show you just how important credibility is in a refugee claim and how it can really make or break a claim. So again, if you look through this document, you'll see the kinds of headings. You know, for example, we have like implausibilities, demeanor, delay in claiming, presumption of truthfulness, you know, medical reports, confronting the claimant with documentary evidence. So again, it really goes through in quite a bit of detail the different types of credibility that issues that come up in refugee claims, and how those are assessed. So the third legal resource from the IRB is this document. I think we've looked at it briefly before. It's Consolidated Grounds, Persons in Need of Protection, Danger of Torture. So this document, again, deals with basically the interpretation of the consolidated ground under Section 97, Danger of Torture. So when you're dealing with a danger of torture case under Section 97, this is something that you are going to want to look at. And then the fourth one that we have here is, again, I believe one that we've looked at before. So again, this is under Section 97, risk to life, risk, cruel, and unusual treatment or punishment. So when you're dealing with a claim under Section 97, this is something that you're going to want to look at. Now, again, I'm not suggesting that these are the only resources that you should look at, but I think that it's a really good start when you're doing legal research and becoming more familiar with, you know, practicing in the area of refugee law. So the next thing I want to just point out to you briefly as another resource is the UNHCR Handbook on Procedures and Criteria for Determining Refugee Status. So the UNHC Handbook, basically, it adds information and guidance and commentary to the 1951 Refugee Convention and how to interpret the convention. The most recent version of the handbook was published in 2019, and it has quite a few additional guidelines on specific situations. I'm gonna show you an example of that now. So there was a link to the handbook on the previous slide if you want to take a look at it later. So I will just bring it up here. So this is on the UNHCR website. Here's the handbook. And so if you look at the table of contents, you will see the kind of things that it covers. So what definitions, interpretation of terms. So it goes through sort of how to define terms like persecution, discrimination, punishment, agents of persecution. And then it goes through the different grounds for a convention refugee and that kind of thing. And then what I wanted to show you is at the bottom here. So hold on 1 second. Sorry, I haven't been able to download this, so I can't Control F search. Okay, here we go. Sorry about that. So one thing I just wanted to show you as an example is this section here on deserters and people avoiding military service. So this is again the section on sort of special cases where they have specific guidance on different cases that can come up in refugee law. So I just wanted to give you this example because this section deals with like military service and how it can intersect with refugee claims, people who have deserted military service, and conscientious objection. So people who are objecting to mandatory military service for ethical, moral, religious, other reasons. And there are refugee claims that do come up based on conscientious objection, where somebody is refusing military service for like moral or religious reasons. And so if you have a claim that's dealing with military service in some way, whether it's like, forced recruitment or evading the draft, right? Like deserting or running away from military service, and how that is relevant to a refugee claim, you will want to look through this part of the handbook to kind of see the commentary about it and how that might help you, prepare for your client's claim. So then the next thing that I wanted to show you are the Irb Chairpersons Guidelines. So there are 9 chairpersons guidelines at the RPD, and basically these guidelines are intended to help guide RPD members in different situations. So they're not the same as like the rules or other law like IRPA or even case law from the courts. But RPD members are expected to apply the chairperson's guidelines in cases that they are relevant to. And if they don't apply them, then they really have to give a good reason for not applying them. So let me show you those guidelines here. So they're on the IRB website. You can take a look at this later, but you can see, so guideline 1 deals with civilian non-combatants fearing persecution in civil war situations. Guideline 3 deals with child refugee claimants. Guideline 4, women refugee claimants fearing gender-related persecution. So if you're dealing with a gender-based claim, you will want to look at this guideline, and it might help you in preparing your legal submissions. Again, in a claim with a woman refugee claimant with some kind of gender-related grounds for the claim, the RPD member is going to be expected to apply this guideline when they're deciding that person's claim. If you look down here, we've got like guideline 8, which is about vulnerable persons. Guideline 9 deals with claims that involve sexual orientation and gender identity and expression, or SOGIE, which we usually just say SOGI. So if you have clients who are, fearing some kind of persecution in a civil war, gender-related persecution, or where their claim involves sexual orientation or gender identity and expression, you should refer to these guidelines to help you prepare for the claim. And then one more thing I just wanted to point out is guideline 8, which deals with procedures concerning vulnerable people. So this guideline has some guidance on some of the procedural accommodations that can be made for vulnerable people. So if you have a client who you think could be designated as a vulnerable person, you will want to familiarize yourself with guideline 8 to help, better advocate for them, especially if you need to apply for some kind of special procedural accommodations for them in their refugee claim. So let's go on to using Canley. So Canley stands for the Canadian Legal Institute. The Canadian Legal Information Institute. It's a nonprofit organization that gets funding from the Federation of Law Societies of Canada. The Canley website offers free public access to over 2 million documents. And as you may know, it has a large database of case law and legislation that you can search. So Canley publishes decisions from the Federal Court of Appeal, and the Supreme Court of Canada. Each of these courts does publish its decisions on its own website, but Canley publishes it all together, which is really great, makes research easier. And Canley also publishes decisions from the IRB. So that includes IAD decisions in immigration matters, and then also some RPD and RAD decisions. Now, one thing to keep in mind is Canley doesn't publish a lot of older decisions from like the 1970s to the 1990s. So you won't be able to find a lot of older cases on Canley. But that said, they are trying to publish more of those older cases on their website. So, if you are looking for something and it's not there, you might have to go and use a different resource. But for the most part, it is really good. Now, refugee claims and appeals are private and confidential for obvious reasons. So any RPD or RAD decisions have to be sanitized and redacted before they are published on Canley, which means somebody has to go through and remove all of the identifying information from those decisions so that the claimants cannot be identified. And because of this, only a small fraction of RPD and RAD decisions are actually published on Canley. The vast majority of RAD and RPD decisions are not published at all. To give you kind of an illustration of this, the IRB makes over, they made over 40,000 decisions in 2019, but only 4,300 decisions were published on Canley. So it just gives you an idea of, I think, how many decisions are actually made by the IRB, and then the fact that a very small amount are actually published on Canley. So let's take a look at Canley here. Okay, so this is the landing page on Canley. As you can see here, where it says search all databases, it has a search box with 3 spaces to enter your search terms. So document text, which basically means you can put in just various search terms there and they will search all the documents for those terms. The next one is case name or citations. So that's where if you have like the case name or the case citation, you can just put it in that box. And then the third one is the note up box. So in that box, you can put in names of either cases or legislation like the IRPA, or a case from like the federal court, and you can find other documents that refer to them. So that's what we call noting up. Now, if you hover over the question mark on each of these boxes, it has some guidance on how to use the search function, as well as some tips to get the best results. You can do, all of your searches from this page, and then you can narrow the results. Or you can narrow things from the beginning by going under this primary law section here and selecting Canada Federal. So again, since we're dealing with refugee law, the jurisdiction is federal, it's not provincial or territorial. And then this will take you to the Federal Canada search page for Canley. And again, you've got the search boxes here, which are exactly the same. You just have to know that the search boxes are the same, but there's a preset filter. So all results that you get from this search page is going to just be from the federal jurisdiction. So I will show you an example of this. So like, let's say we put in, so this is just a previous search I was doing, just to give you an example of it. Okay, actually, let's just do this. Okay, failure to claim. So I've done the search term failure to claim, and you can see that there are 1,864 hits. And if you click on this box here, you will see these are the jurisdictions. So this is one type of filter for the search results. And so you can see it's already been ticked off Canada Federal. So again, if you're doing research in this area, if you do your search from this page, the results are already going to be filtered to just give you federal results. Now, just take you back to the previous page. So you can see there's underneath the search box, there's a list of primary law sources that you can both access and search using Canley. So first of all, we've got legislation. So you find like IRPA, and IRPR. Now under the courts, they've got each level of court and where the coverage on Canley started. So if you look at like the federal court, you can see that the Canley coverage of federal court cases started in 1997. And right now they have, close to 36,000 cases from the federal court on Canley. And then below that, we have the federal boards and tribunals. So you can look under IRB, you see the Immigration Refugee Board of Canada, and Canley carries IRB decisions starting in 2004. And currently in their database, they have close to 54,000 decisions. Now, if you click on, a court or a tribunal, it will take you to a new search page that will automatically narrow the results to the court or tribunal that you've selected. So you can do that search here, and any results that come up will just be from the federal court. So again, depending on the kind of research that you're doing, if you're getting a lot of hits, you want to narrow down the research so you get the results, you get the most relevant results for the purpose of your research. And so sometimes you will want to actually narrow it quite a bit if you're getting thousands of results. Obviously, you can't go through all of those. You can also just browse recent decisions. So for example, I'm on the federal court page now. If I scroll down, you can see, here's a list of all the most recent decisions from the federal court in chronological order. And if we go to the previous page, the same thing with the IRB. If you click on that, here's the most recent decisions that have been published from the IRB. So the next thing I want to talk to you about, I'm not sure how familiar you are with legal citations, so I want to explain them before we look at the Canley search function more closely. So first of all, what is a legal citation? So a legal citation is the information that is used to identify and refer to a particular case. So it includes like the party names, the name of the court or tribunal, the year of the decision, and sometimes it has other information that will help you locate the case. So generally you need the legal citation to find a case and also to refer to a case if you're making submissions to the RPD or to the RAD. And learning how to sort of identify legal citations will also help you figure out and know information about the case before you even read it. So looking at the slide here, you'll see that I've put some citations for each court and tribunal to show you what they look like. So if you look at the top, we've got the Supreme Court of Canada, and I've put the Ward case there that you'll probably remember from our state protection class. So if you look at the citation here, we've got the first one, which is Canada, Attorney General v. Ward, 1993, Canley 105, SCC. And then we've got a comma here, and then we've got a second citation, 93 to SCR 689. Now, when you have two citations like this for the same case, it's called a parallel citation. So the first citation, 1993 Canley 105, that is a citation to Canley. So if you put that citation into Canley, it will pop up. And basically, this just 1993, that means the year the decision was made. Canley, because it's a Canley citation, and then 105, that is, I believe it's probably just like the 105th case listed from 93 with this Canley citation. And then SCC here tells you that it's the Supreme Court of Canada. So it's the Supreme Court of Canada case. Now, if you look at the parallel citation for this, this is actually from the Supreme Court report. So this would help you find the case in a very well-known series of court reports, which is called the Supreme Court reports. And so the way you would find is you'd say, okay, so 93, that's the year of the decision. 2 is the volume number, SCR, Supreme Court report, and then 689, that generally refers to either like a page number or a paragraph number. So again, we don't really use these citations as much for newer cases because there are easier ways to find cases, which I'm going to explain in a minute. But I just wanted to make you aware, like when you see a case like Ward and you see 2 sets of citations after them, they are called parallel citations. And the reason that we give parallel citations is because it's to allow people to find cases in an easier way. So for example, somebody might not have access to the Supreme Court reports, so you give them the Canley citation, which makes it a lot easier for them to find the case. Now, since about 2000, the Supreme Court has implemented what we call neutral citations, neutral legal citations, which is basically, it's a legal citation that an individual court will set, and it makes it easier and more uniform to refer to and to find cases. So I've got an example of a neutral citation on the slide. So this is the Supreme Court case of Vavilov from 2019. So this is an example of a neutral citation. So it shows you the 2 parties, Canada, MCI, Minister of Citizenship and Immigration, and Vavilov. So Vavilov is the last name of the respondent in this case. And then we get on to the citation. So 2019 tells us that the case was decided in 2019. SCC tells us that it's a Supreme Court of Canada case, and then 65 means that this is the 65th decision that the Supreme Court has issued in 2019. So I think the neutral citations are a lot more straightforward and easier to sort of understand and use. And luckily in Canada, neutral citations are used across the country now and have been for quite a few years. So it definitely makes citing and looking for cases a little bit easier. So just to give you a couple more examples, if you look further down the slide, we've got the Federal Court of Appeal. So this is a neutral citation from the Federal Court of Appeal. We've got Lee v. Canada. So the appellant name in this case is Lee, and the respondent is the Minister of Citizenship and Immigration. This tells you that the court is the Federal Court of Appeal, and this is the first case that was decided by the court in 2005. Okay, and then the same with the federal court. So, Orania is the last name of the applicant. It was decided in 2018, and it was the 390th decision issued by the court in that year. Now, lastly, I just want to point out the citations for IRB decisions. So IRB decisions don't have a neutral citation, and they're only published on Canley. So they use the Canley citation. And again, as I just explained before, since RPD and RAD decisions are private, the ones that are published are redacted and sanitized so that the personal information, the claimant's identity, cannot be discovered. So you'll see here, this is an example of the Canley citation for the IRB. So it just says, it will always say, if it says XRE, that means that it's either an RPD decision or a RAD decision. So of course they can't put the person's name, so they just put an X. 2020 tells you that it was published in 2020 on Canley. And then again, this is just a number sequence that shows, you know, what order it was published in on Canley. And then in parentheses, we've got CAIRB, which just stands for Canadian, the Immigration Refugee Board. So that just, you know, this information tells you that it's a 2020 case from the RPD or the RAD. And if you click into the decision itself, you'll be able to see if it's actually from the Refugee Protection Division or if it's from the Appeal Division. You know, the Canley citations are used when a court or a tribunal doesn't assign a neutral citation. So in the case of the IRB, or for example, in the Ward case at the top from '93, when there were no neutral citations at the time. So hopefully this kind of helps you understand a little bit more about how the legal citations work, and when you are, you know, dealing with researching case law, what this information means. Okay, so now that we've gone through legal citations, I want to take you back to Canley and look at a case quickly with you. So this is just an example I want to use. So this is the Vavilov case from the Supreme Court of Canada, 2019. So I just wanted to kind of walk you through what a decision looks like and to take you through the elements of it in case you're not really familiar with them. So first of all, we've got, so here, this is what the case looks like on Canley. So we can see at the top, Supreme Court of Canada. It has the citation right here. So Canada, Minister of Citizen Immigration, v. Vavilov, 2019 SCC 65. We've got the caption, which is the names of the parties. And then, so we've got the parties here. And then if you scroll down, you can see these are the names of the justices who decided the case. And then when we get to this section, this is called the head note. And the head note is a summary that's put at the top of a reported decision that basically sets out the basic elements and facts of the case. And then it will also, it might reference like legislation or other cases that are relevant to the decision. So this is not actually part of the decision itself. This is something that the person, somebody who publishes the decision, will write about the case, so that before you read the case, you can read the head note and just get like a basic idea of what the case is about and what the outcome was. So in Supreme Court of Canada cases, the head notes are usually very long. In other cases, sometimes they're only a few sentences. So this is a very long head note. And then after the head note, we get to the cases cited section. So that means that it will list all of the cases that are referred to in this decision. And then it will also list the legislation here, the statutes and regulations cited. So all of this legislation was cited in the decision. And then we also get a list of other, you know, international treaties that were cited, and then other documents like, you know, academic texts and things like that that were cited in the decision. Now, the great thing about Canley is that there are links to all of the cases that were cited. So if you're reading through a decision and you say, oh, I want to know what this other cited decision says, you can just click on it and go to it. So it really does make going through a decision quite easy. So after you get through the head note and the references, then you get into the decision itself. And it basically explains the decision that the judge made and the reasons for the decision. So federal court cases are decided by one judge, so there's only one set of reasons, but the Supreme Court of Canada has 9 judges, and sometimes they decide the case differently. So when that happens, sometimes there'll be what we call a majority judgment, which is the decision that the majority of the judges have made. And then there might be a concurring decision as well, where like one or a few judges agrees with the result of the majority decision, but for different reasons. So they might want to give different reasons for their judgment. So that's called a concurring decision, concurring judgment. Now, when judges don't agree, the judges who are not in agreement with the majority might write what we call a dissenting opinion or a dissenting judgment, where they explain why they reached a different judgment. So in Vavilov, there is just that, and if you scroll through, we're not going to go through it, it's an extremely long case, but you will see the different judgments within this one case. So again, I just kind of wanted to show you this to get you a little bit more familiar with what some of these cases look like. That's a Supreme Court of Canada case. Now, this is a Federal Court of Canada case, and you can see that, again, because it's the Federal Court of Canada, there's only one judge who made the decision. There are no headnotes on this. It just jumps right into the judgment and reasons, and that is what it looks like there. And if for some reason you want like a PDF of it, you can click that, and then you get this version from the Federal Court. Okay, I think, let me just see what my next slide is. Okay, so, I think what I'm gonna do is we're gonna end it there, because I don't want to talk about the next slide and then not be able to go into the next. I want your mind to be, fresh with this information when we go into the next part. So I have a few more slides to finish up on the legal research that we can do at the beginning of next class. If anybody has questions right now, I can answer them. Otherwise, we will pick this up next class. And once we finish this legal research section, we will go into our discussion on credibility. If you happen to have any specific legal research questions about how to do something or how to look for a particular thing in your legal research, please feel free to email me during the week, and I can try to cover it in our next class. Okay, so I don't think there's any questions. So thank you for your time, and I will see you all next week.